And with that very brief Maryland update, I'll turn it over to Jessie to cover the Virginia laws.
So, as Julie alluded to, Virginia has had a slew of new laws, in part because this is the first time that the Democrats have held both the state house and both chambers in about 5 years. So, there has been a lot of bills percolating over the last number of years that have finally come to fruition. This is an opportune time for us to be doing this presentation because the governor's deadline on a number of these bills to make a decision on whether to veto or to sign the bill, passed on the 23rd. So right now, what we're looking at is the up-to-date look at what is coming out of the most recent Virginia legislative session. So here on this first slide, I just provided a bit of a timeline on what we're looking at as far as the effective dates to be mindful of all these different laws. We're going to go through chronologically. So for those of you who are creating a checklist of things you need to address, we'll be covering the sort of new ones that are going to go into effect in the next month or so first, and then moving on to the ones that are more a little further out on the horizon. Next slide, please. So the first big change that is coming very soon is Virginia's continued expansion of non-compete prohibitions. So taking back a little on the history here, Virginia's original law restricting the use of non-competes went into effect back in July of 2020. That law, consistent with sort of trends around the country at that time, prohibited using non-competes with what the legislature determined to be low-wage workers. And how the legislature defined low-wage workers was employees whose average weekly earnings were less than the average weekly wage in Virginia, and that's determined annually and published annually. So those folks who are under the $30,000 range over the last number of years have been falling under the definition of low-wage worker and can't be subject to a non-compete. Last year, effective July 1, the law was expanded to prohibit non-competes for anyone who's classified as non-exempt under the FLSA. So that would be anyone who's hourly, anyone who is not a salaried exempt, meaning both the salary and the duties test under the FLSA from overtime, regardless of how much you're paying them. So you could have some folks who are earning very high hourly rates or a high salary, but doesn't meet the duties test. Under the new Virginia law, those individuals could not be subjected to a non-compete. Next slide, please. So there were two new bills that passed this session that are going to further add to that non-compete limitations. And the first is a little bit broader as far as the applicability. The first is that as of July 1, 2026, any agreement that is signed or entered into, and that's going to include an amendment or reissuance of a pre-existing non-compete, is not going to be enforceable to the extent that the employer terminates the employee without cause and does not provide any type of severance in connection with that termination. So it's going to be an interesting nuance here in that you're not necessarily going to know when you're having someone who is an exempt employee that meets the pre-existing requirements for someone to have a non-compete under Virginia law. You're not necessarily going to know when they're entering into that agreement, what the circumstances are going to be of their separation, whether that non-compete is going to be effective when they leave when they're separated, X number of years or X number of months in the future. So really what this is going to do is for those folks who have non-competes that were signed after July 1 of 2026, it's going to force employers to think a little bit more strategically about the separation. So, of course, if someone is terminated for cause, the non-compete can still be enforced. If someone leaves voluntarily, the non-competes can still be enforced. This is really the idea and sort of the policy behind this is preventing employers from binding someone to a non-compete, limiting their options when the employer decides to end the relationship without any justifiable reason or just for their own business reasons without any reason based on what the employee has done, and doesn't offer employees that garden leave concept cushion of some form of severance while they wait out that restricted period. So it's going to be for those employers who are looking to still enforce non-competes, it's going to be a matter of thinking strategically about the separations and about how you structure severance packages. Also passed, that's going into effect July 1, is a little bit more specific to the individual industries. New non-competes are going to be prohibited with anyone who's considered a healthcare professional. And I've got that definition in the slide, but it's really anyone who is licensed or registered with the state, the Board of Medicine, Board of Nursing, optometry, social work, psychology, except in limited circumstances surrounding the sale of business. So doctors, therapists, for the most part, are not going to be able to enter into new non-competes after July 1, 2026, unless it's a matter of, for example, someone's purchasing the practice and they don't want the doctor who they're purchasing the practice from to go next door. Those types of restrictions are still going to be enforceable and applicable, but you're going to need to make sure that they fit within the scope of that exception in the law. So the one additional expansion on the non-compete law important to recognize is that this is enforced through private cause of action and civil penalties. And the way that Virginia is structured is a little unique compared to some other jurisdictions. Virginia's penalties trigger when someone is asked to sign a prohibited non-compete. So that applies to the restrictions that are now coming into play for the healthcare professionals, as well as the pre-existing restrictions on having low-wage workers and non-exempt workers sign these restrictions. In many jurisdictions, it's once the employer actually tries to enforce the agreement that there's potential penalties, attorney's fees, et cetera. In Virginia, it is when you ask someone to sign an agreement that is prohibited by law. So just be very cautious of making sure that the agreements that maybe we've been using for years and years, making sure that HR and anyone who's administering new onboarding paperwork knows about these restrictions, being cautious about not having folks to sign it. And then finally, there is a posting requirement. We haven't seen the updated notices come out yet, but there is a posting requirement of providing employees with notice on the non-compete law. Next slide, please. So the next big change that is also coming on July 1 of this year is a pay history and a salary history and pay transparency law. And this is a trend that we're seeing in those jurisdictions, like Julie mentioned, sort of the Mid-Atlantic, New England area that tend to be a little more employee friendly. And just the policy background behind it is the idea that individuals' salaries at another job, people may not advocate for themselves and move themselves up the salary rung, and that tends to disparately impact certain groups who are not as likely to be in higher level salaries when they're moving into another position. So Virginia's law prohibits employers from actively seeking wage or salary history from a prospective employee. If the employee shares that information and says, hey, I was earning XYZ at my last job as part of the negotiation, that can be considered, but it can't be asked for. Similarly, employers should not be relying on, salary history, or any type of salary or wage information in considering whether to hire someone, in determining someone's wages, or thinking someone has too high a compensation level that they're not going to bring them in to interview or hire because of the salary ask that they might be making. So that is from the sort of forward-looking perspective of, as people come in the door, what we can ask them. From the public-facing perspective, there's also going to be an obligation in Virginia to disclose on both public and internal posting every job the expected wage, salary, or wage range, and to do that in good faith. So that is going to be really important for anyone who's posting positions in Virginia as of July 1, 2026. It's interesting the way that the legislature has structured the enforcement here. This is enforceable both through civil penalties administered by the Labor Department and a private cause of action. And the way that the private cause of action works with respect to job posting is that if there's a claim for failing to disclose the wage range or failing to set that wage range in good faith, the employer has to be given an opportunity for 15 days to get notice and to cure that. So an employer, gets notice, hey, you've got a posting that doesn't have a salary range on it. The employer has 15 days to correct that before they can be subject to civil penalties or to a private cause of action. But once someone provides that notice, anyone else can rely on that notice for that 15-day notice period. So if you have, Jane contacts you and says, hey, you didn't set a salary or wage range in your job posting. 20 days later, we haven't corrected it, Bob can sue based on that private cause of action. He does not have to separately provide his own notice. He can rely on the notice of someone else. So really important to both make sure that the postings are going up correctly when they're going up, and then also be mindful of the fact that if anyone raises concerns about it, you want to look into that very promptly. Next slide, please. So also, we saw in the most recent legislative sessions our expansions to the Virginia Human Rights Act. This is the civil rights legislation in Virginia. The VHRA currently prohibits discrimination based on race, color, religion, ethnic national origin, sex, pregnancy, childbirth, related medical conditions, age, marital status, sexual orientation, gender identity, disability, and military status. So this is a catch-all, large, expansive anti-discrimination statute. Interestingly, there was some news around it because it was going to be one of the first pieces of legislation to this effect in the country. On May 19th, the governor actually vetoed a bill that had passed that would have added menopause and perimenopause to the list of protected categories. The governor had originally tried to send it back to the legislature asking that the legislation be amended so that it was a study on whether that bill was necessary first. Legislature sent it back to the governor as it was originally passed, and so the governor vetoed it, and there's not sufficient votes to override that veto. So we're standing with the current VHRA definition, but that of prohibited categories, but that is still a broad definition. Under the new law, there's been an expansion in that the definition of employer for all claims under VHRA is employers with 5 or more employees. So being mindful of the fact that this is a lower threshold than, for example, Title VII or the ADA. This cleans up some of the issues for those of you who are in Virginia. You may be aware that for some categories it was 15, for some categories it was 5, for some categories. So it's actually somewhat helpful in that it provides a clarity of the definition, but it does mean that if you're a smaller employer in Virginia, be aware that now there is this expansion that is potentially bringing the VHRA down to you. It also expands the amount of time that someone has to file a charge of discrimination with the Virginia Office of Attorney General from 300 days to 2 years. So essentially doubles that time that someone has to pursue a claim after an alleged discriminatory action. Next slide, please. So also on the July 1st, 2026 train, we have an expansion of Virginia's wage payment and misclassification penalties. These are the penalties that apply for failing to pay wages in Virginia. So if someone is misclassified, does not get their overtime, or if someone is not paid for time worked, these are the penalties that come into play. It expands the definition of employer, and most importantly, for those of you in Virginia, this is potentially triggering the way that this definition has been amended, likely going to be a subject of litigation, but is potentially triggering individual manager liability for non-payment of wages if there is a high-level manager who is responsible for payment of wages. That is consistent with some of the other jurisdictions in this area that do have the potential for individual liability for non-payment of wages. It also expands the definition of wages to make it clear that it includes all forms of wages, not just hourly wages, salary. It includes commissions, tips, bonuses, and damages. It also lengthens that statute of limitations to 3 years, and requires that employers maintain pay stubs for 3 years, and finally allows for collective action. So it really doesn't change anything as far as the compliance side other than retaining those pay stubs for 2 years, but it emphasizes the importance of making sure that classifications are correct and that wage payments are being made correctly, because it increases the potential liability and potential costs of a misstep here. Next slide, please. So this one is a little bit easier. Virginia has also implemented protections for voluntary emergency responders. I've laid out the information on the slide, but the big thing is if you have folks who are voluntary emergency responders, that are actively called to a state of emergency or an emergency alarm. Generally, there are now protections for any type of retaliation against them. There are certain positions where someone's essential based on the statute or contract where you don't have to provide them with that time away. But generally, for someone who is a voluntary emergency responder, this is requiring and protecting their ability to take that time to satisfy their duties. Next slide, please. So moving to, so everything I've talked about up to this point are July 1, 2026 pieces of legislation that are going to go into effect. So something that those things should be on your immediate radar. Looking a little bit further ahead, Virginia did join the cohort of states that are pushing towards a $15 minimum wage. Virginia's current minimum wage is $12.77. Consistent with this push, that minimum wage will increase again in January 1st of next year. And then January 1, 2028, Virginia will join the states that have a $15 minimum wage. Important to note, there will also be CPI adjustments after that. So Virginia's minimum wage, unlike some of the other jurisdictions that just have a flat ceiling at $15, Virginia's minimum wage is likely going to increase slowly over $15 as those annual CPI adjustments occur. So just being mindful if you have folks who are on the cusp of minimum wage that you're going to want to make sure that you are paying them correctly and that you're looking ahead strategically and budgeting for those increases. Next slide, please. So the one that's been making the news a lot is Virginia has become the first southern state to both implement mandatory paid sick leave and paid family leave. So what does that mean? Focusing first on the paid sick leave. For those of you who have employees in Maryland and DC, this is going to be familiar to you because it is fairly consistent with those laws in Maryland and DC. Requires employers to provide all employees with 1 hour paid sick leave for every 30 hours they work, up to 40 hours per year. The law will have rollover requirements. So if someone's accruing through the year, they get to roll over unused leave to the next year, though there can be caps on how much leave they can use per year. The effective dates are going to phase in. So this isn't an immediate thing for most employers to worry about. The soonest is going to be those with 50 or more employees. This requirement to provide this paid sick leave is going to go into effect July of next year, so 2027. Employers with 25 or more employees get included January 1st of 2028, and then everybody, one or more employees expands out on January 1st of 2029. So there is, particularly for small businesses, going to be time to plan for this. We're also expecting that there is going to be some regulations, guidance coming out. The use of paid sick leave is fairly consistent with the uses we see in other jurisdictions. It's for the employee's physical or mental illness, need to seek care for themselves or a family member related to those mental or physical illnesses, or to seek the safe element of the leave, to seek services or relocation or pursue court cases if there's an issue of domestic abuse, sexual assault, or stalking. I will note that unlike some of our other local jurisdictions, the Virginia paid sick leave does not include in its paid sick leave purposes parental leave. So that is a little bit different from some of the other jurisdictions we're seeing around. But we're expecting that there's going to be more guidances, that there's going to be more notice, but being aware that this is on the horizon, and particularly for those of you who are rolling out new policies, we've been seeing some employers getting questions from employees because they're seeing this is making headlines of when do I start getting my paid sick and safe leave. Just being aware that this is on the horizon, but not immediate, and being ready to communicate that to employees. Next slide, please. So also on the horizon, going chronologically before we hop to the paid family leave, is overtime for domestic workers. This is going to extend Virginia's overtime pay laws, which, like most other jurisdictions, require 1.5 times the regular hourly rate for any hours worked over 40 in a work week to domestic workers, which will include housekeepers and au pairs who are previously excluded. Interestingly, the way this legislation bounced back and forth between the governor and the legislature, the law is only going to become effective on July 1, 2028, if it's reenacted next year. So next session of the General Assembly, that's early 2027. If they reenact this law, then the law will go into effect on July 1, 2028. If they don't, it will not go into effect. But for those who are in the space of having domestic workers, who have their own domestic workers, being aware that this is potentially on the horizon, but not guaranteed. Next slide. And so the final big change that we're looking at, and this is a 2028 horizon, is that Virginia is joining those states that has paid family and medical leave insurance program. So that for those of my clients that are not familiar with this, the way I've been describing it, it's really a publicly administered short-term disability system. And for those of you who have employees in DC, you are familiar with this. DC already has its paid family leave insurance program up on its feet. Maryland is still working on it, has been bumped and bumped and bumped a number of times. So presumably we're going to see Maryland's go into effect before Virginia's, but it remains to be seen at this point. The program in Virginia is going to be administered by the Virginia Department of Health, and there are going to be significant implementing regulations that are going to be forthcoming. The way that the program works is that it is funded through payroll contributions from the employer and the employee. The exception is that employers with 10 or fewer employees are not going to have to contribute to the fund, but there still will be payroll deductions from those employees. Those contributions and the building of the fund that is going to pay out these benefits is going to start April 1 of 2028. The amounts that are going to, the employer and the employee will be paying into the fund are going to be set by the VEC and consistent with the statute. So stay tuned for that as we get closer as far as the obligations and the implementation. And as we generally see for those who are using an ADP paychecks, the standard payroll companies usually catch up and are prepared to help implement those types of withholdings once that comes into play. For those who are doing their own manual paychecks, maybe a little bit more complex and take some additional steps. And then employees can actually start applying for the benefits December 1 of 2028 with the idea that so essentially at that point they can start taking those benefits and getting those benefits. Next slide, please. And so what those benefits are is that they are wage replacements for up to 12 weeks of leave for a number of purposes. And they are generally consistent with the FMLA purposes, even though this is going to apply to employees who are in jobs that they may not be FMLA eligible because of the size of the employer. But the purposes are going to be caring for a child, family member sick, the employee sick and or has a serious health condition that makes them unable to perform their own position. There is a covered service member who's the employee's next of kin or family member that they're caring for. There's exigencies related to the fact that a family member is in the armed forces or has been called to active duty, or those safe purposes I talked about in the context of sick and safe leave, seeking safety services for the employer or family member if there's domestic violence, sexual assault, or stalking. So an individual who needs to take time away from work is going to be able to apply through the state to have wage replacement benefits for up to 12 weeks of time off for that. There are going to be caps on the benefits that get paid out. So someone who is a very high or higher wage worker is probably going to be hitting that ceiling, which is going to be established by VAC. So they're not going to be seeing a complete wage replacement or close to complete wage replacement. And there are provisions to allow the employee to coordinate benefits. So these leave benefits are going to run concurrently with any FMLA leave that the employee is entitled to. And then also the employer can dictate coordination with short-term disability and other leave policies. So if you already have a parental leave program or you have a short-term disability offering, this can be coordinated and synced with that. So it is not going to be a situation where the employee is necessarily going to be stacking this 12 weeks on top of the short-term disability, on top of a parental leave, or on top of some type of unpaid leave. It's going to be a matter of explaining to employees and coordinating exactly how the different types of leaves and the different types of programs that the employer offers works. But we've got time for that to come, looking at, again, December 1st of 2028, but do have that on your mind and on your planning if you have Virginia employees, and be prepared to have those discussions because, again, this is making news in the area, and we are seeing employees come with questions about, when am I going to be able to take this? So not quite ready to be implemented yet. And if Maryland is any suggestion, the VEC has a fairly heavy lift ahead of it in setting up and implementing this. So, April of 2028 is the earliest that we're going to see contributions. Whether they're going to have everything set up properly by then or whether they're going to need to have amendments to extend that timeline like Maryland has had remains to be seen. But certainly a lot to stay abreast with in Virginia and to be prepared. And I know we ran through things extremely fast, to get everything in today, but please don't hesitate to reach out if you have folks in Virginia and need some help complying with any of these new requirements.
Thanks, Jesse. There's a couple questions for you in the chat. I'll just go through them so everyone has an opportunity to hear. So first question is on the salary, the wage transparency law in Virginia. Does the mandatory disclosures that have to be made, is it just base salary, or does overtime eligibility and bonus eligibility have to be included as well?
So it is the wage. I mean, typically most employers are posting the wage range. So it's not, base salary. I think for recruiting purposes, bottom line is it's base compensation and what someone can expect to earn. So if there are contingent factors such as discretionary bonuses, things like that, you don't have to include them. But from the perspective of the employer, if you're trying to recruit someone, most of our clients in jurisdictions that are already requiring these wage disclosures are wanting to have their compensation levels look as generous as possible. So they are including reference to, base salary range expected between X and Y, but also eligible for overtime, eligible for bonuses. But what they're looking at right now, or as far as the law is concerned, is a good faith representation of either the expected hourly rate or the expected base salary.
And on that same law, would you advise an employer to ask a candidate about salary requirements during the interview process?
I think that you're playing with fire a little bit there because during the interview process itself, I would potentially wait until you are at a later stage, just because we don't want a situation where the employer can be accused of fishing for someone's hours expectation, have someone come out of the interview and say, well, they asked me what my expectations were, but I interpreted that the way they phrased it as seeking my wage history or my salary history. So I think you want to be, if you are going to ask that question, I think you want to be really careful the way you do it. And you don't want to be making decisions based on what the employee's wage or salary expectations are. So I think that the conversation about what your salary expectation is to make sure that you're offering a package that's going to appeal to the individual who you've selected are better had at the later stages of the process. So after you've conducted that, initial interview, not because the law strictly says you cannot ask someone what their expectations are, but because of the way it's phrased, the way that it's phrased, and depending on who's phrasing it, we don't want employees to turn around and say that this was fishing for, what the expectations are is based on what you're currently making, or that you're seeking a sort of backdoor.
And for the person that asked for a repeat on the information on the wage disclosure, pay transparency law, I put that slide back up. Who would be covered under this law, Jesse? Would there be coverage if an employer, let's say, has an office in Virginia, but the worker could be in any location because they're working remotely?
Yeah, so that's a great question, and I'll go back and double check to make sure that the legislature hasn't opined on that. But um, in the legislative history and the discussions there, this is a big issue that employers have been seeing around the country as far as whether or not the job could be based in Virginia, particularly if you're posting for a remote position or a fully remote position where someone's not going to be reporting to anywhere but could be working from their home in Virginia. Colorado actually was the very first jurisdiction that implemented something like this. And so that's why you actually see in a lot of job postings for remote positions, you see these very specific pay requirements. And that started a few years ago because when Colorado passed their bill, they specifically included language in there saying if this job could be based in Colorado, if it's remote, you have to include these postings. And by the way, multiple jurisdictions have now started passing bills saying you can't include a caveat in your posting that, this is a remote position, but it can't be performed from California, Colorado, and the list of the states that have the pay disclosure requirements to avoid that. So I would say for local folks, if you are hiring someone who's going to be based in Virginia, who could be based in Virginia because it's an entirely remote position, or it's a very strongly hybrid preference position. So, coming into DC once a month or once a week, and they may be working in Virginia for the other, 4 days a week, 80% of their time. I think you want to be really careful, and over compliance with all of these potential all of these wage disclosure requirements is the best way to go, especially because of the potential for a private cause of action and civil penalties. I mean, granted, the nice thing with Virginia's law is it does give you a chance to correct it. So if you have someone reach out, and I think part of it was the concept on there are, with the other states that have these laws, there have been individuals and groups that essentially go on fishing expeditions and find postings, and sue over postings, even though, the individual really had no intention of, applying for that job, but they are based in Colorado and have a tech background. So they're suing someone who is hiring someone fully remote in Colorado. At least the nice thing with Virginia's law is that before someone can sue you, they have to give you notice and give you the opportunity to address it. So again, if you have a situation, even if you are not based in Virginia, but someone reaches out and says, I think you're violating the Virginia wage law because you're posting a remote position or a hybrid position, take that seriously and let's take a look at it together. Because generally all of these states want to include as many employers as possible and as many posters as possible.
And this law is effective July 1st, right?
That is correct.
And a question on the sick leave, the new sick leave law. If an employer has PTO and includes, sick and vacation all in a PTO policy, do they need to make any adjustments to comply with this law?
It depends on what the PTO policy currently looks like. So that employers can satisfy the requirements, just like in Maryland and DC. You can satisfy the requirements of the paid sick leave through offering a more generous program of PTO. So you don't have to just do paid sick leave. You don't have to stack paid sick leave on top of PTO, as long as the PTO you're providing is at least as generous as the leave that's otherwise being offered. So the big thing that we see as far as PTO policies when we've seen these come in Maryland and DC as examples, and we have clients who have pre-existing PTO policies that they want to keep. The big things that we're looking at are the use restrictions compatible with what the state requires. Often the PTO policies are going to require a carve out because most PTO policies say you have to request this leave at least 1 month in advance so we can plan for it. You can't do that when it comes to paid sick and safe leave purposes. So usually the PTO policies we're having to draft carve out saying, except if it's a protected paid sick and safe leave reason. Similarly, things like rollover, the PTO policies have to comply with the rollover requirements for the states as far as the minimum amount of leave that needs to be rolled over. So we would need to look at and just make sure that the accrual, the rollover, and the use and compliance elements are consistent and at least as generous as the paid sick leave. Make any changes necessary to the PTO policy, but PTO itself, in theory, can satisfy the requirements. It's just don't assume if you're an employer that you are already satisfying the requirements just because you offer PTO.